class, and welcome to Module 5. We're here in Albuquerque, New Mexico, where I've stopped off at the Standard Diner here. It's one of my favorite restaurants here in Albuquerque. We're going to be having our class here from that Standard Diner. I'm going to go ahead and step on in here in just a little bit and grab a early dinner. I want to say right off the bat, the Standard Diner is one of my favorite restaurants, and they've got an amazing dish, mac and cheese with green chili. Let me tell you, mac and cheese sounds like a pretty simple dish, but man, the green chili mac and cheese here is amazing. It's really one of the best dishes you can get here in Albuquerque, and that's saying a lot because we got great food here in New Mexico. Now, I say this with every module, but be sure you read Chapter 5 before we get too far into the material. Again, before we start with this lecture, read Chapter 5, and I want to touch upon something with Chapter 4. I was a little unclear about the issue of service. There is such a thing as the long arm statute, and I should have spent a little more time talking about that in the previous lecture, but the long arm statute does allow you to serve somebody outside of the jurisdiction if they've established minimum context, if it does not offend our notion of fairness. So be sure you're familiar with the long arm statute, because you may see a situation where somebody's been served out of state and you assume automatically, no, the service is not valid. And that might be partially my fault because I kind of implied that might be the case. Again, folks, there is such a thing as a long arm statute that does allow you to serve somebody out of state. Generally speaking, it occurs when there's been a tort committed by the defendant or allegedly committed by the defendant in that state. And again, the notions of fairness are not offended by serving that person out of state. Now, in Chapter 5, we're going to be talking about one of my favorite subjects. In fact, it's really one of every attorney's favorite subjects. What is that, you may ask? It's not going to trial. Now, we talked about litigation in the last chapter. We talked about who has standing to sue. We talked about the process of obtaining a jury. We talked about the process of going to trial. But that is really the worst case scenario. Generally speaking, as attorneys, we don't like going to trial, and the reason is quite simple. We don't know what's going to happen in a trial. We don't know what a jury's going to say. We could have a great case and lose. We could have a terrible case and win. A jury may award damages that are far in excess of what we thought was a worst case scenario. And let's be honest, with our lawsuit with Super Mega Mart that we're involved in, these facts aren't really particularly good. I mean, quite frankly, if we're selling cereal that had asbestos in it, we really don't want that information to get before a jury. And quite frankly, we don't want that information getting repeated over and over again, where it might gain some traction in the court of public opinion. So how do we avoid a trial? Well, the easiest way is the case was dismissed, but that's really not up to us. We're the defendants in that case. That's up to the plaintiff or the judge if the judge finds that there's some sort of technical error with the filings. If the plaintiff decides they don't want to proceed with this case, they may choose to dismiss that. But let me be honest, we shouldn't bank on that. That's not a strategy, a long-term strategy for winning this case. So what else can we do? Well, we can compromise. We all are familiar with what compromise is. We do it every day in our lives. Compromise in the legal setting could involve having the attorneys get together, talk about the case, and see if we can work something out. But compromise can go beyond that. It can also involve something called mediation. Now, mediation is basically having a third party assist the parties in reaching a resolution. Think of it as a facilitator. You're a facilitator. A mediator is a facilitator to the parties, trying to get something to work out, to see if there's a middle ground. A lot of times emotions are very raw, and in the movie clip that I've showed in this module, there's going to be some movie clips. One of the movie clips is an example of mediation, and you can kind of see why there's mediation in place there. That is a family law matter. That's a divorce, and it's a very contentious divorce. But you can see why a mediator in that situation is very helpful, because quite frankly, if there was not a mediator, that particular negotiation probably would have gone nowhere. So mediation is one form of compromise. And keep in mind, a mediator is just not some guy off the street. A mediator does have high ethical standards. Read over page 100. It talks about the standards for a mediator, and be familiar with those, because again, a mediator does have to act with a certain amount of ethical behavior, because if parties start believing that the mediator is not a fair party, or the mediator is working on behalf of the other side, that really harms the entire process of mediation. Another form of compromise, or another form of resolving a case before it gets to trial, is called arbitration. Arbitration, if you will, is like a mini trial. It is a third party, an arbitrator, who hears the case, who hears either the evidence in the case or the legal issue in the case, and decides whether or not there is a solid case, or how it should be ruled upon. Now, generally speaking, there's two kinds of arbitration. There's voluntary arbitration and there's mandatory arbitration. And this is important to note, because the difference between arbitration can be very significant, whether it's voluntary or mandatory. Example, a voluntary arbitration, usually there's not much of an appellate process with that. If you have an arbitration and you voluntarily entered into it, that decision by the arbitrator is final. This is also very distinct from mediation, because a mediator is trying to get you together to work things out. An arbitrator is basically somebody you agree to hand all the information to and decide the case for you. A mediator can't do that. An arbitrator can. Now, mandatory arbitration is arbitration either set by law or set by statute or by administrative code. And with mandatory arbitration, generally speaking, there is an appellate process. There is an opportunity to appeal that decision, but it's what we call a de novo appeal. A de novo appeal means that the judge who's going to review this in the court is not going to look at all the evidence again like the arbitrator did. He's only going to look at the process to see if the arbitrator made any legal mistakes or made any errors in regards to his analysis of the evidence. He's not going to second guess the arbitrator. He's not going to retry the issue. And a lot of times, if he finds that there is a mistake, he's simply going to send it back to the arbitrator and say, you need to fix this. So a de novo appeal does not mean you get necessarily a second bite of the apple. You can see the appeal for this for a lot of corporations, a lot of companies. It saves a lot of expense. It also saves a lot of uncertainty and heartache. If you have an arbitration, the matter generally moves a lot quicker. And again, it saves you a lot of money. It's going to save our client a lot of money if he were to elect to go with either mediation or arbitration. But quite frankly, Jack Murphy contacted me, and he's got some crazy ideas about mediation and arbitration. I'm going to be perfectly honest. I've got some concerns, but I need you, my legal team, to look at his proposals and see, are they something we can do? Are they something we should even consider doing? Look at his proposals, look at page 100 and the ethical standards for mediators, and decide for yourself whether or not this is something we can proceed with. But right now, I'm going to go ahead and head on inside. We're going to be starting dinner here in just a little bit. I'm really excited about this dinner. We're going to catch you from inside.
Well, class, it was a little bit crowded in the standard diner, so we decided to come back a little bit later. It's early evening now. We're about to be seated, but I wanted to take a look at the desserts and see if there was anything that I wanted to get. And let me tell you, this cream puff looks incredible. We're definitely going to be trying one of those. I know this mac and cheese just looks like mac and cheese, but trust me, it is so good. You definitely got to try this if you're up in Albuquerque. And I went ahead and got the cream puff, and let me tell you, this thing is huge. This is the biggest cream puff I've ever seen, and it looks really, really good. I'm going to put this ketchup here so you can kind of see how big it is. Class, thanks for tuning in. We'll catch you next week for Module 6.